49, Your Lordship, I appeal for the appellant in the lead matter. As per the office report, Your Lordship, the service is not complete in the connected matters, Your Lordship.
Nice.
There are two connected matters. Services incomplete.
Well, in this matter,
Office report dated. Yes.
we are for the appellant in this matter.
Which one?
There are contesting respondents are 1 to 4, my lord, in this
No, but
matter.
once all of them are clubbed together. We'll
Yes. So my learned friend is representing the other parties in the other respondents, and I'm also representing the others because they are in the National Commission. They are all the same.
If you are appearing for the unserved persons, file your wakalat, that will take care of it.
Yes.
Do that.
Yes.
Office report dated 21/11/2025 reflects the details of service and shows that some of the respondents in these cases still remain unserved as on date. Needful in that regard shall be done by the next date of hearing.
My lords, I'm for the respondent 1 to 4.
Yes.
I'm trying some time to file my counter, my lords.
Respondents who are represented by learned counsel are at liberty to file their counter affidavits well before the next date of hearing to enable the learned counsel for the appellants to file their rejoinders thereto, placed on 16th February. Yeah.
Victim
50 services awaited.
In the lead matter, it is complete, I believe, Your Lordship.
3 and 4 in the
My lord,
50.1, 3 and 4 are.
3 and 4 are performer respondent. My lord, may I
You'll have to file an application.
in fact, my lord, respondent number 3 is the petitioner in 50, my lords. My lord,
Well, he is not entering appearance.
you can accept notice for him, my lords.
I'm only one respondent. I do.
What about 4 then?
There's 4, my lord, there are 3 petitioners before the Honorable High Court. 2 have come before this Honorable Court, my lord.
We are not going to delete parties for the mere asking. So you'll need to file an
Yes,
application because you have to do it at your own risk and peril.
I'll file an
There's
application.
no question.
I'll file a performer.
Office report dated 22/11/2025 reflects that service is not complete in so far as SLPC number 25520 of 2025 is concerned. Steps shall be taken in that regard by the next date of hearing. Based on 16 Jan.
My lord, may I make a submission, my lord? The respondent, the main contesting respondent is state, my lord. They have been served in both the cases, my lord. They may be directed to
We
file.
don't know who's appearing.
I believe
Mr. Samar
One is
Vijay,
appearing.
Mr. Samar Vijay Singh has entered a memo of appearance in the second matter, my lord.
Not in the first matter. They filed a memo appearance in the first matter, not in the second matter.
In the second matter,
No one is here today.
my lord, my lord, because my lord, we have moved an application for stay as well, my lord. That may be also considered on the next date, my lord, with the enter appearance, my lord.
Registry is directed to print the name of, don't say publish, print. Print the name of Mr. Samar Vijay Singh, learned counsel, who entered appearance for respondents 1 and 2 in SLPC number 25520 of 2025 in the cost list.
Highly obliged.
number 51.
May I please, my lord?
Yes.
My lord, in this case, my lord, the notice, my lord, the counter is being filed, my lord. But the subject matter is what is over here, and the counter says something very different, my lord. My lord, we were not made a mandatory party while the High Court the petition was filed and an order was obtained, my lord. What they have, they say that we have done all these things, my lord. That is something very different. Even, my lord, in that proceedings, we were not even called for giving our reply.
This R4 and 5 have not come.
I have come, my lord. I have filed.
No, for R4.
R4 and R5 yesterday, but it's not on record. Can be taken on record now.
What is your name?
My name is.
You don't know your name.
My name is Imran, and
You're not the counsel.
Mr. Chand Qureshi.
Who is the counsel who is taking notice for that?
Chand Qureshi.
Mr. Chand Qureshi, learned counsel. We are informed that Mr. Chand Qureshi, learned counsel, is entering appearance for respondents 4 and 5, and time is sought to enable him to do so and file his counter affidavit based on the usual order after that. Rejoined at if any may be.
One aspect I may bring to your lordship's notice, in this case, after the High Court's order, the appellate authority considered the matter and appellate authority considered it appropriate to remand the matter to the
So the stay issue is gone now.
Yes.
And
And
what you mean?
My lord, what has
We were only concerned with the stay which
my lord, that's correct, my lord, but my lord, these orders are becoming precedents now, my lord. At least that will be decided, my lord, because
What steps
because-
have you taken against the appellate order now?
my lord, the difficulty is that, my lord, appellate
At
order,
the appellate order, you need to challenge it, isn't
my lord,
it?
that matter is being remanded back, my lords, now. My lord, ultimately there is a finding, my lord. See how they are.
What remains in this then? This was only in relation to
correct,
the
yes.
stay order then.
I bow down on
If
that.
the appeal itself is disposed of, what is it that you want us
Nothing,
to
my lord,
do?
but it is being disposed of, my lords. But the fact is that we were not given a fair opportunity.
We are
to
only
do our job.
concerned with the stay order.
I bow down. What is
Then what remains? Don't say all that also.
I may be permitted
We are
to
informed that the appeal from which the present special leave petition arises in the context of the stay order passed therein has now been disposed of.
On 26 July 2025.
Don't say now then, has been disposed of on 26 July
2025.
2025. July itself.
Yes, just 2 days after the filing of this SLP, it got disposed of. So perhaps they could not
26
quantify.
July 2020. In that view of the matter, this special leave petition does not survive for consideration on merits and is accordingly closed on that count.
Lord, with liberty to approve for appropriate purposes.
This is only the stay order. Why do you need that?
This is the West Bengal.
West Bengal.
matter. 26. Your lordship had directed that the tainted list be issued. The untainted, we've all taken the exam. The list has been announced. Now, what is before my lords is on the 26th, you have 39 related matters which pertain to what are the next steps, but also pertain to this issue of can the government give 10 marks, up to 10 marks for prior teaching experience. So your lordship will be seized of all of this on the 26th. There are 39 matters.
What's the new regulation?
Yeah, my lord, that's
Why would it come before us directly?
my lords. The question is, it is listed before your lordships, and the Supreme Court had earlier heard this challenge and had upheld a division bench's order of the High Court, which said that this is within the purview of the legislature and the executive to have such rules. So all those questions will be before my lords.
When is it coming up?
26.
One of the
Item 90.
26.
Item 90.
one of the matters,
39 cases.
one of the matters that the unsuccessful candidates and the fresher in 2025, they also challenged that the division bench judgment, and your lordships have dismissed it in that case.
Yes.
We have the order.
There's one matter of concern.
Let's take this up on 26.
We have also moved an item for intervention. Clarify, because today evening the results are to be announced for class 9 and 10. Lordships may clarify that the results should be announced and the selection process is not going to be disturbed.
No,
Yes.
they
Not
don't
said it.
I'll explain to your lordships in.
Why do you anticipate that?
Well, what is happening, I tell you, Lord, I have got
Calcutta High Court.
well, Calcutta High Court,
has passed an order?
Lord,
Calcutta High Court, a single judge has seized herself of this matter and is hearing all these issues, including issues which your lordships have heard in the past.
No,
I
this is not
appeared there,
correct.
we told her that.
This is not correct. Calcutta High Court is hearing the constitutional validity of it.
Anything about
Lord,
Let the Calcutta High Court proceed on its own way.
Calcutta High Court now seized of 76 matters.
Yes.
Your lordships, yours the entire
And
list.
in one matter, certain directions have been given. Of course, we are coming on. Not just according to us, just opposite to your lordship's main judge.
In fact,
But in fact, interfering.
anyhow, bring those cases before.
we have Not we have moved an
We need not say anything at this point in time.
yeah, I
I have
have
not said anything earlier. Nothing to be clarified.
Nothing to be
One
clarified.
request, Lord. Just one request, Lord. Just one request. Lord, until your lordship decide this point of this teaching experience, legality, on this point, Lord, kindly pass an order, Lord, this High Court should not interfere. Lord, we are
No. Why should?
We are not going to say anything at this point in time.
Make a submission. I am supporting my friend, my lord.
We all
We are
are
for some
supporting.
No, Lord, I oppose.
who are not in the list of tainted candidates. Now, they started a proceeding earlier to somehow expand that list and bring in more people. That proceeding got rejected. SLPs came and your lordship rejected that SLP, your lordship remembers. Now some other people have started a similar new proceeding, again to expand the list. Now the learned single judge is
No,
again
no.
now entertaining that and
Yes,
taking it up.
yes.
The issue is completely
So
different.
now the
But
problem is, we have taken the examination. Now, it has been
This
kept.
is a mess of your own
It
making.
has been kept.
Yes, yes.
Your lordship may.
Impossible, my lord, it is really.
Your lordship.
We won't say anything today.
We are going as
Just
per
adjourn the matter to 26.
We'll come up against those orders.
Bas, give no guidance.
It's
No
very
interpretation.
difficult. We are
We'll file an SLP against them.
tainted or untainted.
But this will appear on
In every
26.
with the other connect.
Will your lordships then place it at a particular time? Because High Court has flooded your lordships with these matters. They are
For them to handle their own votes.
your lordships, they are hair splitting
Lordship,
the
the state should
grounds.
move a transfer.
And
Yes,
all of
that
them have been decided by your lordship.
Lordship, the state.
It's coming up on 26 November.
Yes, sir.
26th year before my lord, 28th before the High Court.
Very good. 26.
But let me say on top of the board if
No,
we
it
can.
is
Well,
26th is a.
No, we are going to just.
Yes,
We are
grateful,
also
man.
filing.
because it's imperative for the lordships
They
to
will
take
be
it.
got the.
No, let this come up along with the badge.
The ID number of that, kindly just, if it's possible, take it on 26 along with that. We are filing SLP.
You filed it. Where is the
No,
post office?
today.
You have not filed it yet.
No.
Calcutta High Court is listed on 28.
28
That's
on
why we are
Friday.
expressing
26.
the see that 26 the matter must be taken up by
Better
the
thanks.
Very great.
Grateful, my lords.
Yes.
allow physical appearances,
Yes.
Because
Agricultural land.
it's been verified now. They filed an affidavit now saying that I
Did they?
state is filed an affidavit on record minutes. It's filed on 21st November 2025.
21st November.
It's a just 2-page affidavit.
Yes.
21st November.
Affidavit in compliance. Is that the one?
Yes, sir. Para 2 minutes.
Does possess agricultural land within district.
They have produced a digital register, Millards. We had produced the handwritten register. That's the only difference.
How much land do you have there?
I have 1.60. This is 60 are here.
Page 3 is the
60.
translated version.
60.
Page 6 is the original Marathi document.
60 hours.
60 hours.
1.5.
That's 6,000 square meters. 1 hour is 100 square meters.
Yes, sir. Around.
I must be ignorant. I am ignorant. I'll just take this up.
1 hour is 100 square meters. Take it from. So 6,000 square meters. What do you say,
As I
Mr.
pointed out on the last occasion, all of this was placed before my lords at the time
No,
of the
but
hearing of
the matter is going on, so how long can we ask him not to go into Pune district? If he has agricultural land there, are you in a position to say that he has other family members who can take up the agricultural operation?
That I'm not aware of.
Then if you're not, then we'll have to
He's
say.
really been handling
How
the
can
agricultural
we
lands.
say that you have land but you can't use it? Livelihood of your family members also you can forget about.
He's obviously been using the land for the last.
No, you
4
were
years.
on the last occasion. You said he wants to go back to build up a political career or something like that.
No.
So that we will make clear that he will only
No
do
question, no
agricultural
question.
operations, nothing else.
No question.
No,
No
we then
question.
clarify.
Miscellaneous application number 1970 of 2022. By way of this miscellaneous application, the petitioner in specially petition criminal number 4684 of 2022 seeks modification of the order dated 16/5/2023, whereby he was granted bail subject to.
It's criminal appeal now.
conditions. Sorry, it's now appeal.
Appeal because it was allowed. It's 1532 of 23.
In
Sorry.
criminal appeal numbers, please. Appellant in criminal appeal numbers. Granted bail subject to several conditions, one of which was that he would not enter into district Pune.
Pune.
Full stop. By way of this application, the appellant seeks modification of the aforestated condition on the ground that he has agricultural land at Koteshwar Wadi. Is that correct? Koteshwar Wadi.
Yes,
Koteshwar Wadi in Mawal. Mawal is what? Taluk of district Pune, and needs to enter into the district to carry out agricultural operations pending disposal of the trial has not. What is the
So
state of
charges
the
are framed in 2022. After that, not a single witness has been examined.
pending conclusion of the trial? The state verified. The state of Maharashtra filed an affidavit after verifying the claim of the appellant that he owns and possesses agricultural land and certified that he has this 1.2100. Is that what we should be? Where do you find this 61?
60 hours, Mullah, at page 3, your lordship sees the translation on the left side, Mullah, 60 hours. 60 hours, Mullah, is there.
There. Certifying that the appellant owns 60 hours of agricultural land in, where are the details? It's no details.
Yes, it is there.
Shankar Ram,
Next page, page 5.
Yes. Because there's the details of village and everything is mentioned.
Some survey number, something, Khata number is there?
Yes, sir.
Khata number is 969.
It's a village.
Survey number is.
Khata number is 969. In Khata number 969,
Gut number 181.
where do you find that?
On the table.
Table, Mullah, right?
Memorandum
Memorandum number and
number,
subdivision number, just above the table. Page 3, just above the table. Gut number 181.
It says gut number or subdivision number?
Lordship, I am reading from
Marathi.
Gut number is gut
It says gut number. In gut number 181. In that view of the matter, the appellant cannot be denied his means of livelihood by preventing him from putting his agricultural land to beneficial use for the use for the benefit of his family. The condition imposed in the order dated so and so is accordingly relaxed to the extent of permitting the appellant to enter into Koteshwar Wadi, Mawal Tado, district Pune, only for the purpose of doing agricultural work. He shall not address any political gatherings, or you're a politician also, joining politics.
Not even an aspirant. Not even
That
an
is what the
aspirant.
other side.
The entire reason why the murder happened.
I can tell you a lot of that. Having spent 10 years of time, I have the qualification, but
Now you have the
qualification,
no doubt.
but no, not an aspirant. Not an aspirant.
Very good. That's all.
Grateful to it.
$54.
Please, and just seek some time under the file count.
Counter. Then cancel for the petition, for all the respondents.
Malan.
For the respondents, seek some time to file a counter after usual order.
That
Earlier,
is
the order dated 22/9/2025 shall stand extended till the next hearing. List on 23rd January.
My appearance may be marked. I had missed the deadline. Right. Okay.
My lord.
My
lords,
Fifty-five.
my lords, we have received the private respondents counter yesterday. We will seek time to file a
No
resolution.
counter.
For other parts,
Counter.
we have sought instructions in the morning. We'll file our appearance and reply.
For which respondent?
For jail board respondent number 4, Your Lordship.
My lord. The Jal Board.
I appear for respondent number 5, Suraj Element.
Fine.
Yes, sir. I
You are
appear.
appearing. You've not filed your counters. Who filed the counter?
I have filed it, my lord. I am informed.
Only you filed.
My lord, I want to bring certain.
When you appear as a party in person, you must not wear the full dress.
I know, my lord, but I was in this court only, so I didn't get
At
the
least
time.
one. The bands you can remove.
Oh, okay. I'll do.
As a party in person, you should not be wearing the dress.
Okay, my lord.
Certain practices one must not.
I know,
discard.
my lord, but I was in this court, so I could not just speak.
Very good.
My lord.
So you filed your counter. And you need to file your rejoinder.
My Lord, we would like to file a rejoinder. We received it yesterday.
My Lord, I would like to bring certain photographs of today morning. Just this shows that the sewer lines are still overflowing since morning, Saturday.
You'll have to file it. Don't hand over documents across.
I have to just, since it was in morning,
File
today,
File it then.
My Lord, I wanted to just say one thing. Since Delhi Jal Board needs to, clean the sewer lines which is overflowing, so the court which has given the directions of stay, they are not bound on them for.
They appear for the Residents Association. Now the impugned order, para 8 Roman 1,
yes.
Milord's concerns directions only to the Delhi Jal Board and MCD to continue clearing
at least.
But why are they not doing?
Because there's a stay. My Lord, there's a stay. From
Your Lordship's order is a stay of the impugned order.
Oh.
So that needs to be clarified, my Lord.
Yes, Your Lord. That cleaning and all that you have to do. We only state the laying of the sewage line through their residential complex.
My Lord, that too.
It will be done for Jal Board, my Lord.
Yes.
My Lord, just one clarification.
Respond number
4
1 filed a counter affidavit. We are informed that respond number 1 filed a counter affidavit, but the same has not been placed on record. Registry is directed to verify the same. Learned counsel for the petitioner seeks some time to file a rejoinder thereto. Respond numbers 4, 5 and 6. 4, 5 and 6. Learned counsel for respond numbers 4, 5 and 6 seeks some time to file the counter affidavits. Usual order affidavit. We clarify that the stay granted on 27/10/2025 is only in relation to the direction of the High Court permitting the direction of the High Court as to the laying of a sewage line
within the 8
lines within the premises of the petitioner, All India Institute of Medical Sciences. The other directions with regard to cleaning and clearing of the existing sewage lines, be it by the Delhi Jal Board or by
Municipal Corporation,
New Delhi NDMC, shall continue to operate. Not MCD. Only MCD. I thought one was brought on.
My Lord, NDMC.
It was stated that the land is in NDMC jurisdiction.
My Lord, they have given a wrong information. AIM says that this land belongs to NDMC, which was not there actually. It is there who are
only. Put NDMC oblique MCD. And whoever has to do it, do it.
MCD is the owner.
Your Lordship, in fact, para 8 Roman 1 of the impugned order records both BJB and MCD. Your Lordship may sustain that.
That's what's been done.
Para 8
Roman 1, my Lords, of the impugned order, page 6.
We further clarified that the direction in para 8 within brackets small I of the impugned order shall also be given effect to.
Please. My Lord.
It only says monsoon. Monsoon is over though.
No, my Lord, it's throughout the year. It is today morning also. It is wrong to say it is monsoon. It is throughout the year.
Even at this stage, though the said paragraph only refers to the monsoon season.
My Lord, a short date should be maybe given, my Lord, because it's a
12th January.
My Lord, can it be a little earlier, my Lord, because the problem is too high there and the things are overflowing. If I can request, my Lord.
The state should we implement the Delhi state government also? It is better because this kind of direction may not to be.
As my Lord,
I'll first clarify, my Lord, I appear for the Residents Association.
Delhi wants, the government wants to acquire any land that is for.
My Lord, it is not acquiring, it's going underground. My Lord, there's a misconception.
You can't say that you will do.
My Lord, this land belongs to a public place, which is not, we are not taking any place, we are going trenchless. We're just going
it would perhaps save you time if the Delhi government is also before us.
They are already a party.
They are a party. Very well. Who is appearing for the government then? Go on. Services are dictated.
Well, services.
Let's see. Public Works Department.
Respondent 7.
And Forest Department. Both are there. service learned counsel for the petitioner is also permitted to effect service of notice upon the learned standing / designated counsel for the NCT of Delhi.
Deeply.
56 perhaps will not be able to take up today.
एक sentence
number देखेंगे.
56 matters obviously jinxed. Whichever date we fix it for,
very kind to me,
whichever date we fix it for, the miscellaneous hearing tends to go on, or some.
I'm sorry,
because of the oath ceremony, will not. Otherwise,
would have reached today.
Whenever it's convenient for us.
Next Friday. Lord, we are here to.
Next Friday we have a hearing.
Next Friday.
3 are there.
Take it on
Hmm. 19th is too far away. We'll keep it on 28th. Or let us see. 28th.
28th.
Friday.
It's a Friday. We already have some hearing matters listed for that day. Hopefully, if they fizzle out, you can have your.
Obliged. Obliged.
Most obliged.
Obliged.
56.
Please, I'm taking a short accommodation. My lords may keep it next week.
Government is sought by the Learned Counsel for the petition. Based on 5th December.
So Article 59, it's a fresh matter. And here we are requesting a notice and stay if it pleases the court.
You are a third party to the.
Yes, so can I just say, the answer to that is yes and no. The reason why I say yes and no is because I am the plaintiff in the first suit which came to be instituted. You may just note the number. It is Civil Suit 1 of 2023. Now that's the civil suit number which carries the present name in the Allahabad High Court. It was instituted, please note the date, it's important, on 25th of September 2020. And it was initially 2020. It was initially.
The suit number is 23.
Yes, because it was initially instituted before the civil judge senior.
Twice it was transferred to the High Court.
Yes, thereafter. So what happened essentially was that I had instituted the suit, and this is very important from our perspective, and it's important from the court's perspective as well, because there's a huge amount of research, historical, archaeological, etc., which has gone into the institution of the suit. Now, after the suit was instituted, as I told you, on 25th of September 2020, there are several, what I would describe as cut and paste or copycat actions which were filed subsequent to the institution of that suit. Thereafter, at my initiative, we made a request to the Allahabad High Court under section 24 for the transfer of the suit. That order also came to be passed on my application, and the suits were consolidated and transferred. There is also an order on the record which shows that my suit has been labeled as the lead suit or the leading matter in the case. Now, what has happened, and my concern essentially over here is, as your lordship would have seen, there is a subsequent suit. That suit is 17 of 2023. And please just note the date. It was filed about 3 years later on 10th of August 2023. Now, in that suit, while all the other actions have been consolidated, what has happened is that the High Court at one point separated that suit from the other hearings. And here you will just find you may please go if you're to page 284. Please just go to page 284 for a minute.
Yes.
And then I'll come to the issue, because according to us, the impugned order suffers from procedural as well as substantive infirmities. So your lordship has an order at 284. I'm not taking you to any great detail. Directly to 288, there's a list which you will find earlier of various suits which are pending. Now in 288, I request you to please go to para 16. Since the original suit 17 of 2023, an application under Order 1 Rule 8, read with Section 151, is pending for disposal. Therefore, the issue of consolidation of this suit with another suit will also be taken into consideration later on. All right, so now that's a tentative observation. Now the next para. Considering the arguments advanced by the learned counsel for the parties and in the interest of justice, now this starts with my suit, original one, and there's a whole bunch, are consolidated. Your Lordship has that. Then para 18, suit number 1 of 2023, that is one of my suit, is described, is made the leading case. Your Lordship sees that as well.
Yes.
It is, however, made clear that the applications pending in the other suits shall be dealt with separately, etc. Now, 17 was segregated. If you see, go back to that paragraph 17. Please just go to para 17. You will find after the suit number 16 of 23,
18.
there is 18 of 2023. So this present suit, Your Lordship's question to me initially was, are you a party to this suit? So in a manner of speaking, I am the plaintiff in the lead suit. But am I formally a party in this suit? The answer is no. Now this suit was therefore, because it was not consolidated, it was proceeding in parallel. Now we come to the issue. I should just mention straight away, Manoj, that I had at one point of time taken out an application under Order 1 Rule 8 myself in my suit, and that I withdrew with liberty, and that was granted. But just keep that aside for a minute. Now please go to the prayer because the High Court in the impugned judgment also has something to say. Please see the prayer in the present application at page 240. So the application itself may be first placed at page 220 if you want to see the opening.
Yes.
So this is the application in order suit number 17 of 2023, P10, begins at page 20. And I take you directly to page 240, directly to 240 in the prayer.
Yes.
Now, this was amended. This was amended slightly, which I will inform the court about. Your Lordships have a prayer. May I place it? It is therefore prayed that the plaintiff, Your Lordship has that, be permitted to sue and deal the suit as representative capacity against the entire Muslim community of Mathura, suit under Order 1 Rule 8, read with section so and so 151 as well, and any other order be also passed as this Honorable Court deemed fit and proper. Correct? Now, the amendment was that as against entire Muslim community of Mathura, it was amended to make Muslim community of India. Just please keep that in mind. So, it is an application for in a representative, to make it a representative suit on behalf of defendants. That's very important. Now, just go to the impugned order.
What was your Order 1 Rule 8?
Sorry?
Your Order 1 Rule 8 which you withdrew.
Yes, therefore,
was it on the same lines?
So, Manoj, it was slightly different, but I might just inform the court. We've got that application and I've actually filed an Order 1 Rule 8 in this court as well. But just have a look now as to what the High Court has done, because we have an issue on this, and then I'll just place my points.
Yes.
Now, please go directly to page 17, which is part of the impugned order, at page 38, para 38, I'm sorry, para 38.
Yes.
May I just read the operative direction first and then go back to the reasoning?
Right.
So just see what the court does first in para 43, and then I'll go back to the reasoning from para 37 onwards. Page 19, Manoj. As prayer made in application Order 1 Rule 8 appears to be somewhat ambiguous. Therefore, the relief is liable to be modified in the operative order in exercise of powers under Order 1 Rule 8 1B vested in the court in the following manner. In the application under Order 1 Rule 8, CPC is allowed in the manner that the plaintiff is permitted to sue in representative capacity on behalf of the benefit of all the devotees of Lord Sri Krishna who may be interested in the suit against the defendant number 1 to 6 and entire Muslim community of India. I'll read on. Let notice under Order 1 Rule 8 1A CPC be issued within 15 days in national newspapers at the plaintiff's expense to all the persons so interested in the suit. Pursuant to this order, the plaintiff may move separate applications, seek consequential amendment in the plaint wherever necessary. Now, let's just go back to this, please. 43.1. Application under Order 1 Rule 8 is allowed in the manner that the plaintiff is permitted to sue in the representative capacity on behalf of and for the benefit of devotees of Lord Sri Krishna who may be interested in the suit. Now, I'm pausing here for a minute. You remember the application itself. The application was for Order 1 Rule 8 defendant. What has been allowed here, it seems to me, I don't know, it's there may be capable of some other interpretation. And then it says who may be interested in the suit. And then against defendants 1 to 6, entire Muslim community of India. So they are converted, order 7, in this application, suit 17 appears, at least on one way of reading it, is representative both on the side of the plaintiffs and representative on the side. So my first point is that, look, when you have a situation where you have an application which is restricted only to the purposes of defendant's representative, I don't believe this can be done without proper notice which the court gives. Now, why do we have an issue on this? The court is completely aware that all these suits have been transferred to the court. So there are already more than a dozen suits which are pending before the court. So the whole thing on the basis of plaintiffs, on behalf of the plaintiff to make it a representative action, is already an action which is there, which is present. Suit 1 of 2023 has been marked as a lead suit. So in a situation like that, without giving notice specifically to the plaintiffs, if you're converting this application, according to us,
the learned judge not aware of the pendency of.
Of course, he's aware of it because he's the one who's there. They are passed the order, my lord. These are original. Sorry.
Is it the same learned judge? No.
Yes, my lord. The matter, because the matters are proceeding, the matters are completely aware. But my lord, so just see this. Now just go back to page para 37. I'm part of the impugned order.
Yes.
Para 37. Page 17. Thus, on a perusal of the prayer clause in the application reveals that the plaintiff have prayed as being permitted to file a suit in representative capacity against the contesting defendants as well as the Muslim community. So there he recognizes defendants. However, defendant number 1 to 6 have denied the fact that in their objection they represent the entire so-and-so community. Defendant number 1 is the committee in the care and management of so-and-so and does not represent the Muslim community. The answering respondent has not sought relief by the court to defend or be sued on behalf of the Muslims of India, and hence it is not to be treated as representative of the Muslim community of India. If we go through the prayer, in the amended prayer clause in the application, it is clear that the plaintiffs have sought permission to sue and deal with the suit in representative capacity against all persons of the Muslim community of India, including the contesting defendants. It cannot be inferred from the prayer clause that the plaintiffs seek to sue and deal the suit in a representative capacity on behalf of and for the benefit of the persons of the Muslim community having the same interest. No other inference can be drawn from the perusal of the prayer clause. Otherwise, it will lead to absurdity. Although the prayer clause in the application under Order 1 Rule 8 CPC is not happily worded, yet on reading the pleadings and as contained in the application, the intention of the applicant becomes evident. No, I'm just pausing here. This has a huge impact on all those other suits, and none of us were before the court in the sense this was separated. Your Lordship saw that earlier order which I mentioned. Now, when there is a lead suit, which Your Lordship saw that particular order as well. This is an order at page 284. I had placed before you 288. Now, suit number 1 of 2023 made the leading case, paragraph 18. And if we were to make it a plaintiff suit, representative suit on behalf of the plaintiffs, it would have to be the leading. It ought to be the leading suit, because this is the suit which has done everything. Everyone else is a copycat and thematically has taken, broadly the issues. So this is, my lords, a very, very serious part, because first of all, there's no prayer in the application. The High Court also is recognizing that it is only a defendant's action, a defendant's representative suit. Then in the final operative direction, which I placed before you in 43, converts it into both plaintiff as well as defendant. I'm not saying that the court doesn't have the power to do so. It may have the power to do so. I think on my reading of Order 1 Rule 8, it does. But then there's a process to be followed. The process would certainly involve specifically putting Order 17, suit number 17 along with the others, hearing all those plaintiffs, and then coming up with a solution as to which would be the appropriate case to make it Order 1 Rule 8 on the plaintiff side, and again, of course, on the defendant side. Now, this, Your Lordships have held it's a very nice expression which our court has used, a two-way street. Please just have a look at that, my lords. Give this. Yes. Yeah, come on now.
2022.
Why are you looking? Please, 1, 2 elements I asked for.
138. 138.
Just once I asked.
Who is on caveat here?
So I appear for respondent number 1.
So there are some other matters also on this side, which your lordship.
There's another matter also. That you are in another suit, perhaps.
Yes.
They are in one suit, you are in another one out of those 15 suits.
This may, according to us, require some.
Both of you are the plaintiffs in two of the other suits. And who's on caveat?
So I appear for respondent number 1.
Who is respondent number 1?
Lord, the Shahi Masjid committee.
Oh, you're for the Shahi Masjid.
Please,
and
we are for the plaintiff in 17.
In the other one.
Other suit.
I believe this will require some consideration by the court. Just have a look. Yes, sorry.
Yes.
Yes,
Two applications have been filed by the other side yesterday itself. They may not be on record, wherein they are seeking the same prayer which they are opposing by view of the SLP Malad.
Sorry? I didn't understand.
They have moved an IA yesterday.
Who has moved?
The petitioner.
Oh, they've moved IAs.
And order 1
before the High Court.
Before your lordship.
That's exactly what I started by saying. Because I am saying if I am the lead suit,
you would want to be the...
Yes, if it is to be done, there has to be a proper process which is followed. You can't have some copycat suits which suddenly come out in this manner. Now just have a look at our court is very...
Somebody who has to join cause with me is joining issue in Supreme Court. We are all plaintiffs.
Of course.
Very surprising. They were given opportunity to file a counter in my order 1 ruling. They did not file a counter. I show the orders.
You know.
How would they be given an opportunity?
They were given because they raised an issue. Please see, there's an order passed.
Anyway, now let me complete.
There is an order passed by the High Court giving liberty to the defendants in my suit and the other plaintiffs whose suits were taken away. And
a specific order. Which
specific order, page 290. They don't avail of it.
Anyway, we see.
And the 290.
Objections, my lord, what they are saying.
Before the High Court.
Exactly, my lord.
Not considered.
No, they argued also, and this petitioner didn't file. Page 290.
My lord, please allow me to submit.
Please see para 3, my lords. The objections against application
plaintiffs in other suits
by the defendants and plaintiffs in the other suits. Counsel for the other suit who desire to file objections against the application obtain the.
But how would they be put on notice? They're not parties.
There was a public notice. There was order passed. Notice was given to them.
My lord, please allow me.
And they appeared and argued the matter. Please see the input order.
Not all of them, though.
No, my lords, we have filed. Please allow me to submit.
No. What about your client, Mr.
They did not file.
You did
No,
not.
so I was just in the midst of my argument and just placing.
Because this is something that perhaps affects your argument also.
No, my argument.
Because your argument was that you were not there at all before this.
No, my argument.
But you were put on notice.
No.
You were asked to
Can
file
I just
objection.
Can I just respond to that? The prayer in the application which I have placed before you is a prayer for defendants. That's why I was just showing you the judgment. It's not a prayer or relief sought on behalf of the plaintiffs. That's my primary concern. That I am
put on notice that the court was.
No, it's not, because look at the prayer, my lords. Look at the prayer. And the court also recognizes that as a prayer. The amendment also makes the. So once you have a particular relief, I am, as far as I am concerned, as far as the plaintiff is concerned, in the lead matter is concerned, I feel that there is going to be no trammel as far as my conduct of the litigation is concerned.
To that extent, Mr.
Yes,
Devan has a point.
That's one point. Which needs consideration.
I have something to say on that.
Okay.
Before the High Court, please allow me to submit. I'll clarify. My lord, when the suits were transferred, 16 suits were transferred in May 2023. After the transferring of suit, this OSUT 17 was filed at that time. So, my lord.
Directly before the High Court.
No,
it was also transferred.
Yeah, District Mathura Court, but it was being transferred later when the trial has already started. So now, my lord, the point is when the Order 1 Rule 8 application as a representative suit is supposed to be filed, it was to be filed before the suit is to be registered. So here, my lord, when you will see, they have just filed it later along with the suit was, and they have filed this suit as a next friend. Because the minor is it is always a minor, and a minor cannot be represented through a representative capacity. It can only be representative through next friend, my lord. So now, my lord, here as a next friend, And as being the representative of the DT, how you can become the representative soon? And then also without after asking to amend the prayer, even the order clearly read what my learned senior has just read. It was clearly about the diversification of the benefit which they are seeking. And apart from it, my lord, the private defendants 2 to 6, the private defendant of OSUT 70 are the private Muslims against which there is no cause of action. Their claim doesn't show any sort of cause of action against the private defendants. So how the private defendant can become the representative of the Muslim community?
What are these applications that you have filed? They have not been put up, is it?
And my lord,
Yesterday?
The applications, my lords, are
Just two things, my lords. Just two things. First point, we pointed out, my lords, they were given.
Who are you appearing for?
I am, my lords, the plaintiff.
You are the plaintiff. Oh, you're together.
So I'm
And you are for the
R1.
R1.
R1. Now,
That's all? Three of you? Anybody else?
yeah, I think that's
over here directly.
Therefore, the first point on no notice, no knowledge goes. They had notice, they did not file objections. Number one. Number two, I think my friend will bear me out.
Very well.
Now, number one.
Better that we hear you on perhaps Monday then.
Very well.
All right.
We'll just adjourn the matter.
Very.
Just on Monday.
Yes. Even the second point, once he argues, I'll point out.
Yes, yes.
It really doesn't subsist, I'll point out. Page 18 is a complete
What was the observation you wanted to read out from this?
No, I'll place it. Thank you.
Could your lordships then consider having it in the second week, commencing from 8th of December?
No, we've not issued notice yet.
Just
We will just hear the matter.
Yeah, just hear it whether you want to
Solid
consider it.
410 now.
Yes.
And this matter perhaps would require some amount of.
Yes,
that's true.
So it will come up on the fresh list and whatever next
Monday.
Monday.
We'll take it up at the end of the list.
Very good. Great.
All right.
Grateful.
End of the list.
Very grateful.
Lord, I am seeking short accommodation, Lord. Lord, in next Monday, maybe list.
Adjournment is sought by the council for the petition. On our interim findings. List on 5th December.
My Lord, next week, my Lord.
Next week only, 5th December.
Great, Lord. Great.
That's item 62. These were an application for transfer of the bench under 408 of CRPC. My lords, both the courts have dismissed my application. My lords, may
And we don't have the order also.
Yes, my
Not
lords.
uploaded accordingly.
Yes, my lords.
Then
Now the issue
look
is
at the sessions judge's order. Session judge's order.
My lords,
Page 39.
Yes, my lords.
Then
My lords, may kindly have page 40 of it. My lords, I will show
you
the.
agreed before the sessions judge that you had no issue with the presiding officer.
My lords, I don't have issue regarding
Then-
the integrity of this.
Well, he says that the presiding officer shall deliver a judgment now. The
Now,
sessions
my
judge-
lords, may kindly.
Now you want to stay because the judgment might be pronounced.
No, no,
You
no.
have to
My
make
lords,
up
I have
your
a
mind
bigger
what you
issue.
want.
My lords, I have a bigger issue which the trial court has agreed to, but they have not taken any actions. My lord, may kindly have P1, my lords. My lords.
I'm not going to interfere with this. On one hand, you say you don't want the judgment now. You're asking for stay on the ground that the judgment might be pronounced.
No, no, my lord.
And then you go before the sessions judge and say that I have no issues with his integrity.
My lord,
He's not delivering a judgment.
No, my lords, there are other issues. My lords may see the procedure discipline followed.
If the presiding officer repeatedly gives, this is the observation of the sessions
Right,
judge
my lord.
perhaps, but your argument was, you are the applicant, is it not?
Yes, my lord.
And then you said that arguments were presented. He was heard only once by the court. He has no apprehension or fear regarding the presiding officer. So the comments were also called for from the presiding
Right, my lords.
officer.
My lords, I will.
Due to heavy workload, a decision was not delivered. So now let the decision be
My
delivered.
lords, my lords may see what they
After
are
the stay of the
done.
judge.
My lords, when the arguments were completed, the trial court, the learned judge, had put up the matter for evidence of the complainant. There are 5 exemptions continuously allowed to the accused. In the comments, the learned judge has said,
Considering all the circumstances, PO is expected to deliver his decision on the date fixed for the decision. No undue adjournment will be granted. So let that happen now. Why should you again try to stall that process?
My lords,
Having
because my
obtained
lords,
this
we
order
see how the proceedings are being conducted, the
Sorry,
leniency.
we don't even know what the High Court said because there's no order also. We find no good ground and reason to interfere in the matter after perusing the order passed by the learned sessions judge on
My lords, 15 September 2025.
on 15th September
15/9/2025.
15 September 2025 as the impugned order
My lords,
passed by the High Court on 19/11/2025 has not even been placed before us. The
My lords, it has not been
petition is accordingly dismissed.
My lords, may at least allow me till the impugned order is here.
No, nothing else.
Great, my lords.
Wait, please, my lord.
Yes.
The High Court does not examine the merits. It states that I have an efficacious remedy in a discharge. In paragraph 6.
But Mr. Dave,
Yes, my lord.
what is more worrisome is the reference to the judgment of this court.
Yes. The judgment is not.
Neeta Singh.
That judgment, my lords, is not applicable. My lords. What is
How is it not applicable? That is directly on the point and says that filing of a charge sheet is sufficient to dismiss a quash petition.
There is a judgment of your lordships, my lord.
Exactly.
2019, which says that filing of charge sheet.
2019, in fact, sitting with Justice Bose, I authored a judgment, a 3-judge bench, no less.
Yes, my lords. Abhishek.
Yes. But that is not brought to the notice of the division.
These are not brought by anyone. The court has placed reliance on with respect.
No, but this Neeta Singh refers to that Radhesham versus Chabina, which is a 227 judgment.
That's the point, my lord. But we didn't refer it.
The difficulty, I'm not blaming you. But here the advocates need to take a little more trouble to at least tell the bench what judgments are there on the point.
My lord, may I just pass on something to your lordship? I didn't want to say this, but please pass this on. This is an order, my lords, which is in a particular form, my lords, with respect. On top is an order, setting aside that order of your lordships, my lords. Just please have the number 6th page, my lords, which is the, again, of the High Court.
Sorry?
6th page, where it says in the High Court, my lords. Now please see this order, impugned order, and see the impugned order here, my lords. Except Neeta Singh, everything else is the same. And therefore, your lordships were pleased to set aside this order and remand it back and ask the High Court, my lords, to decide it on merits, my lords. Paragraph 5, the first, at page 2. So we faced this problem many a times, my lords. I know my lord had been the Chief Justice there, my lord, all that, but this problem is there, my lords. This order. Now it's a simple thing. Decide it on merits, reject it on merits, my lords. I'll come now. It will come here, my lords. Go back to the High Court, my lords. That's what I'm praying for. And your lordship's judgment is there. Justice Bobde's judgment is there, which says.
I refer to 2 earlier judgments.
Absolutely.
In that judgment.
We refer to them.
This Neeta Singh doesn't refer to any judgment on the point.
No, it doesn't.
It extends the 227 judgment, and nobody informed the bench that these judgments are there. There's a judgment of a 3-judge bench.
These are by the bench itself, my lords, with respect. These are by the bench itself. That's why this is not placed by. No,
in Neeta Singh. In Neeta Singh, Mr. Nagamuthu appeared, and he doesn't inform the bench of the judgments which are directly on the point.
I don't want to say much.
Issue notice.
Because my next date is 23rd January, my lords.
5th January.
Lordship, please.
Should be effective by almost.
Grateful.